Hey everyone, Harry here to talk about the hearing today in Judge Scott McAfee's courtroom in the Fulton County case. Just to set the basic agenda here, remember the case was proceeding along pretty well. Then it totally hit that huge bumper or hole in the road. And for 2 months now, we've had this circus really involving the allegations against Fonnie Willis. You know my views that McAfee let that go way too far. But anyway, it's that episode is over now. It's up on appeal. And I think McAfee wanted, among other things, to just re-establish the case as moving on track. So that, it's his choice of motions to hear and the like are, I think, have to do with, okay, now we're back in business. Remember, he's not giving a stay, though he's permitted Trump and the others who have Trump is one who's joined in the motion, but everyone who's joined in the motion to disqualify to take it up on appeal. But he's not staying the proceedings and they're moving forward. That could come to shove if the Court of Appeal winds up taking the appeal from the order not to disqualify her. I do not think that will happen, but we'll see. But until then, at least for a couple months, and it should take no more than that, maybe less, for the Court of Appeal to make a decision whether it's going to take the case. He wants to, just right the train, as it were. Okay, so that's the basic, I think, procedural context. Now, he just issued an order saying these are the things we're going to cover. And the number one thing in time and substance was Trump's motion to dismiss the case because, he argues, the indictment alleges core First Amendment protected behavior, and it would, violate his constitutional First Amendment rights to subject him to criminal penalties for this. Now, this is one of a half dozen or so motions to dismiss that Trump has raised. He could have done, any of several, I think. But this one, makes some sense. It's part of a big motion that Trump filed with several bases, and this was a sort of a lead one. Also, it's kind of very basic. I think it's I'm kind of dancing around what it really is, which is like a total loser. The DA at one point referred to a gorilla in the room, and by which he meant Judge Tanya Chutkin's opinion, part of the an opinion she issued last December 1st, that just completely methodically demolishes this argument. What's the argument? This is core First Amendment protected speech. This is a really tired and stupid argument, but I'll try to keep it together. What he's saying is, this was all he was doing was expressing his views, even if they were false. But his honest views that the election had been rigged or there were improprieties with it. That's all that happened. That's core political speech, especially, this was an interesting angle. You heard this. The question is, how much more will we hear it, especially because he's the president of the United States. So a glimmer of a suggestion that the First Amendment analysis is different for that reason. But anyway, just a guy expressing some views that the election went the wrong way, and just maybe those views were false, but that doesn't make them criminal. Just a really make weight straw man argument. So, and one that he's been making around the country, never with any success, because there shouldn't be any success. The basic notion here, and the DA picked up on it, is nonsense. He's not being prosecuted for making false statements. There was this whole long opinion and Supreme Court plurality opinion that Trump's lawyer, I thought, pretty ham-handedly displayed not very good preparation, is sort of moving through papers and trying to find quotes and stuff. It was obvious that his, associate knew it better than he. But anyway, the case in the Supreme Court had to do with a statute that made it a crime basically to say false stuff. And the Supreme Court recognized properly, even false statements have some First Amendment value. And he argued this, again, to really beat this dead horse into the ground. The horse is dead because it's not the charges, if you look at the indictment, are not about saying false things. They're about words, yeah. But words are how you accomplish crimes like obstruction, like RICO, which is what he's been charged with. So, he used false claims to try to get state officials to break the law and to try to obstruct the result and turn it over away from Biden, the rightful winner. But it's not the falsity that matters there. It's that it's part and parcel of criminal activity, obstruction, conspiracy, and the like. Most conspiracies also with words, or words to get Mike Pence. Yeah, he used words, false words. Mike, you have the power to do this, etc. You need to do this. That's not what made it a crime. What made it a crime was the actual attempt to obstruct the election. I mean, it's a very, very basic principle that I think a first grader would easily understand, and all the laws out there anyway. So it is now. McAfee was his methodical self, heard out both sides, but it's just a crappy argument that relies on a complete misconstruction of what the DA has actually charged, and the DA got back up and made that pretty clear. Moreover, it's been completely debunked by other courts, most particularly Chutkan. So I don't see that going anywhere, but it's a relatively big motion, in pages or like pounds that he will be doing away with. So it's part of the sort of clearing of the underbrush. Another big underbrush, by the way, would be his immunity claim. And for that, I think we'll see McAfee hold off until April 25th, at least, maybe even later. Those are the dates, respectively, for the argument in the Supreme Court on immunity and whenever the decision issues. So anyway, that was the Trump motion. Then no one's reported on this, but he also considered a couple claims by David Schaefer, and I found those interesting. The Fulton County case, I said this before, can kind of be subdivided into two basic conspiracies, even though they're charged as one RICO. And one involves all the national actors like Trump, like Mark Meadows, like Rudy Giuliani. But the other is all these Georgia electors who, as alleged, knew that they were lying when they asserted that they were legitimate electors, went ahead anyway, et cetera. Also, you could make a First Amendment claim, but they haven't. But David Schaefer is sort of first among equals there. He was the head of the Republican Party, and he's the guy who, if other Georgia members of that part of the case were to plead, he's the one they'd cooperate against. He's the most culpable. So it's worth keeping our eye on him. In general, when a trial is really imminent is when you see pleas, and we saw four of them in this case, and then everything got off the tracks. But if they get back on the tracks and are really moving, you'll see, I think, people from Georgia pleading and giving testimony against David Schaefer. The David Schaefer's claims here were kind of bizarre, not just weak, but he basically tried to say you should take certain verbiage out of the indictment because it's inaccurate. It's inaccurate to describe it this way, under the facts. But I think at best, he was making a claim that you could make an argument to the jury about whether how you should consider certain elector statements and the like, or if not that, about his honest belief. But that again would be a classic jury argument. So I don't see those going very far. But it's interesting that McAfee puts him in play. And as I say, when this case, more approaches trial and a trial date, and Fani Willis says we're ready to go, let's do it. Let's get it on in July, I think. We'll see what happens there. And remember, this is supposedly many months to pick a jury, and the prospects, at least for a completed trial by November, I think are remote. But the prospects for presentation of evidence may be less so, and the prospects for pleas, either on the federal part of the case, the Washington D.C. actors, or the Georgia part of the case, where the top of the ladder here is Schaefer. Those remain possible. So McAfee is just back on track, and it's interesting that includes Schaefer. He didn't issue opinions on either of these. That's his more normal practice. But he typically gives a sense of where he is. That's something a good judge does, so that the advocate has a chance to address the judge's concerns. It's a classic thing that Eileen Cannon doesn't do. She just stays, Delphic and lets people prattle on. But so McAfee has done that, and he'll, I think, absorb the last of the arguments and come out with opinions, which he's probably already started in fairly short order. So, and that'll be one of Trump's, remaining biggies. And the others may be big, but they're, pretty weak, I think. The immunity is a big one that, they'll wait on. But I'm talking like selective prosecution, for instance, is one that, it just doesn't hunt. And then, but also on the Schaefer side, we'll see how McAfee, who's getting, at least from one side, a argument. Let's do this for one trial only for everyone and do it soon. We'll see a little bit about how he's thinking about the case and how he might carve it up by how he's deciding to hear these motions. So today, the First Amendment one, and then Schaefer also in play, which, as I say, I found interesting. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.